Welcome into the Cheeley Law Review. My name is Ben Burnett. Today, Bob and I are going to talk about preparing a plaintiff for deposition. Bob, welcome.
Good to be here with you, Ben, as always.
One of the parts in discovery before you get into a courtroom are depositions. I know them from life as an elected official, probably not as near as familiar as you, but have definitely done more than one. How do you get a client ready for a deposition, and what do you seek to make them understand?
It's very important that they get a very good understanding from their lawyer as to what to expect from the defense counsel, what kind of topics they're going to cover, and how they may try to be painted into a corner, the kind of questions. So we cannot, during a deposition, we cannot do what are called speaking objections, so we can't telegraph to our client. But the answer is that
they're on their own.
They're on their own. It's like sink or swim. And but that underscores the importance of preparing them properly ahead of time. And so one of the things we tell them is your case. They need to understand what the elements of a case are that we've got to prove. Like, for example, in all cases, whether it's a business case or a breach of fiduciary duty in a business case or a catastrophic brain injury or a medical malpractice case, there are three basic elements that you got to prove. One is liability, like in the case of a breach of fiduciary duty, that there were fiduciary duties that were owed and those were breached, and that breach was the cause of the plaintiff's damages. So I always like to talk about it in terms of a three-legged stool so that people can picture what I'm talking about. The three legs of the stool is, the first is liability, second is causation or proximate cause, third leg of the stool is damages. And that helps them to understand, okay, Bob is my lawyer. He's got to depend on me as the plaintiff to help prove each of those three elements.
All three?
All three.
One more important than the other?
No, all three are equally important, because if you don't prove
all
three, the stool falls over. It won't stand up.
Talk about the preparation that goes into a deposition. Will you put a client through a mock deposition with other members of your firm just to tear them apart, let them get used to the stress?
Sure do. We bring them in and coach them up, and then we go through some trial scenarios. I always tell the client, I hope that I'm a lot more overbearing on you than you're going to experience.
Yeah, of course.
You know,
it's the difference between practice and a game.
Yeah, it's like summer camp in football. Coach wears all of us out.
If you do it right, it's the hardest thing you do.
Right. We bring the client in and spend sometimes all day with them. Sometimes we'll video and then ask them an hour's worth of questions and then go back and watch the video and let me critique them.
Don't do that. Don't fool with this.
Right. And don't do things that cause you to be trapped, such as looking like you're a deer in the headlights. Don't be looking at me for help during the deposition. Also tell them that they need to take a breath after each question and think about what their answer is going to be.
Regardless. Because you need to get it to a methodical place.
Yeah, and say it in as few words. Give your answer in as few words as possible. You're not there to prove your case to the lawyer on the other side of the table questioning you. That'll come later at trial. So all you're there for a deposition is to answer the questions that are asked of you. And if they don't ask all the right questions that I would have asked, or that I did ask in the preparation deposition.
In the scrimmage,
then you're better off than no worse for the wear.
Talk about those mock depositions and why they are so important. Is it the stress factor that a client is going to sit under? Is it the fact that they have the opportunity to practice an answer? And how is that different than the real thing?
The stress component is very important, that they experience that level of adrenaline rush. Sometimes they don't realize that they can get flustered until you really push them on a line of questioning, and so they need to experience that before they get into the real deposition. So that's one of the goals that we have, is to see if we can get them to the point where they're not able to think straight and give intelligent and cohesive answers. Another thing that we want to do is I want to show them how they communicate. Did they effectively describe, for example, how their life has been materially changed, the quality of their life compared to what life was like before the injury, if it's a catastrophic injury case, or for they got partnered up with the wrong business partner if it's a breach of fiduciary duty case. So we want to show them, we'll give them a teaching, like we'll bring in a whiteboard and we'll put on the board, these are the things that you need to picture in your mind that you've got to cover to give a good, solid answer to the essential elements that are in this case, the three legs of that stool. These are the concepts that you need to keep in mind after discussing with them to see how this case, has affected their lives. So that helps them get that mental picture that these are the topics that I've got to make sure that I cover when I get my answers.
This has been another episode of the Cheeley Law Review. We'll see you next week, everybody.